If a grantor conveys property to a grantee by a deed, but the grantee doesn't sign the deed, is the grantee bound by the deed's terms? A gift to a university raised that question in Langman versus Alumni Association of the University of Virginia. Margaretha Langman and Caleb Stowe bought a commercial arcade in 1986. They executed a $600,000 promissory note payable to a bank, secured by a deed of trust on the arcade. Langman and Stowe subsequently decided to fund sizable gifts to the University of Virginia by transferring the arcade to the university. They conveyed the arcade to the university's Alumni Association by a deed that identified Langman and Stowe as grantors and the association as grantee. The deed stated that the arcade property was subject to the deed of trust securing the note and provided that the grantee assumed payment of the mortgage obligation. Langman signed the deed, but nobody from the association signed it. The association's director acknowledged Langman and Stowe's gifts, and the association's attorney recorded the deed. The association's accountants included the mortgage as a liability on the association's financial statements. However, the director told the association's auditors that he disagreed with treating the mortgage as a liability because he didn't think the mortgage was the association's responsibility. After the conveyance, the association represented itself as the arcade's owner, and Stowe managed the property. As manager, Stowe ensured that mortgage payments and operating expenses were paid from the arcade's income. If the income wasn't enough to cover the amounts owed, Stowe personally paid the difference. The association treated those personal payments as charitable contributions from Stowe. In 1989, Stowe couldn't fully cover the arcade's expenses, and the bank notified Langman that the mortgage was in default. Langman made the payments necessary to cure the default and asked the association for reimbursement, but the association said it wasn't responsible for the mortgage debt. Langman sued the association in state court, seeking a declaration of the parties' rights under the deed. The association argued, among other things, that it wasn't bound by the deed's mortgage assumption provision because nobody from the association signed the deed. After an evidentiary hearing, the court concluded that the association hadn't knowingly accepted the assumption provision and that the parties hadn't intended the association to be responsible for the debt. The court thus decreed that the association wasn't liable to Langman, Stowe, or the bank. Langman appealed to the Virginia Supreme Court.